Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Are you ready, everybody? All right, listen.
Hello, lovely people and wonderful audience out there. Another opportunity is here with us for us to have the community and the law brought to you by BWF Solicitors. When can you apply for British citizenship as a child who has come to join your parents in the UK? We're going to answer that, and we're so delighted and happy to have you around, and we have lawyer Eunice Champon also to help us answer those questions. So stick and stay. Let's get on live on our channel BWTV at Facebook and YouTube, really, and also to share it when we come on. Welcome to the community and the law.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345. Or you can send a text 07950 422780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
AA Music Entertainment presents Emmanuel Praise on the 25th of May at the Pavilion, 143 to 146 Oxford Road, Reading, RG1 7UY, featuring Irabna, Joyce Blessing, and hosted by Alex Achampo. Show starts at 6 p.m. with a concession price of £15 for children from 5 to 16 years old. Tickets are £35 standard, £60 double, £60 VIP. Includes a VIP seat, meet and greet the artiste, take pictures with the artiste, VIP snacks, water and drink. Get your tickets at alexachampon.com or call 0744 741 7321. Emmanuel Praise with Irabna and Joyce Blessing, and hosted by Alex Achampon. It's guaranteed to be awesome.
Hello, hello, hello. Once again, as another opportunity for us to meet as a community and also to really discuss what things we need to know and also make sure that we do our things right when it comes to it, especially immigration matters. My name is Oreku Frimpon, and I'm delighted to be your host for these 2 hours when we have the opportunity to do a community and brought to you by BWF Solicitors. Now, this afternoon, I have mentioned, and I know you know, we are going to have a discussion on when you can apply for British citizenship as a child who's come to join your parents in the UK. How do you do that? How are you going to make sure it's successful? Well, I will obviously ask you to contact BWF solicitors, but you need to know the details. So, Laura Eunice Champong, our resource person and guest from BWF solicitors, is going to help us discuss that and also know what to do. Remember, it's a Saturday afternoon when you join us. Click on the like button, share the link, and get people to come join us. And I'm so happy in the comment section, people are so excited about this afternoon. Good afternoon to all faithful viewers. That is what Helena is saying. Helena, you live with us on YouTube. Thank you very much. Daniel is saying, Sandra, thanks for all you do at BWF Solicitors. Tilly Duma, as usual, is calling all to come on board. So, come on, let's go. Let's get it doing. Let's get it going because it's an exciting afternoon this afternoon and today because we're going to get things right. So if you're ready, let's delve into it together. Let me first of all introduce our resource person, a sweet mom, and also, as we know, lawyer Eunice Achampo. Lawyer Eunice, good afternoon.
Good afternoon, Kweku. I hope you're doing well.
I'm so excited. Why? You know what? The sun is out. It's so exciting out there, and everybody is happy. So
Yes,
this opportunity, yes, we should be happy.
definitely. The sun always brings a smile on people's faces and it changes people's moods as well. So it's a good thing.
What I will ask people to do is get a glass of water on the right hand side when it is
Yes.
like too hot. Take a sip because we're going to delve deep into our discussion. So thank you for coming, leaders.
Thank you too. And thank you to our viewers for joining us for today's program. I know our Saturdays are usually busy, but if you've made the time to join us, we are grateful for your support and your viewership. So God bless you so much.
Right. So with that, let's see. A very happy client who has sent us the review. I keep asking, and I'm going to continue to ask you to go on Google review, leave us your comments, leave us your feedback, and we will work with them. Particularly, Loretta says that I would like to express my sincere appreciation for the professional and highly competent assistance provided by BWF solicitors in relation to my successful application for indefinite leave to remain from my initial consultation through to the approval of my application and then demonstrated a comprehensive understanding of immigration law and an unwavering commitment to excellence. His attention to detail, clear communication, and methodical approach ensured that every aspect of my application was prepared and submitted to the highest standard. I was particularly impressed by the prompt responses to my queries and the ability to navigate complex requirements with clarity and confidence. Thanks to their guidance and expertise, so to speak, my indefinite leave to remain application was approved without any complications. I would not hesitate to recommend BWF solicitors to anyone seeking reliable, professional, and knowledgeable legal representation in immigration matters. I know this should bring an extra broader smile on your face, Lawyer Eunice.
Yes, I believe that she has enjoyed our service and um all her comments are great. I mean, what more could we have done? Right from the way we handled her application to answering her questions and then ending up in a successful application. So we are truly, truly grateful for your feedback and we do hope that you will recommend others as well.
Well, thank you, Loretta. Yeah, as Lawyer Eunice has said, recommend others as well. But there's one other thing that BWF Solicitor does that we also as workers and members of the family, need to appreciate and commend as well. One of our very own, sometimes when myself and Ona Manyeti are not in, we have Pamela come in to host the community and the law for us. And on Thursdays, she does the English version of the discussion we hold in P. Congratulations, Pamela. Pamela is a caseworker at BWF Solicitors, and she has had her Masters in Law or Masters of Law in Professional Legal Practice. Very young, enterprising, full of ambition, and she's had a Masters of Law. So we salute you, we say well done, and we're so proud of you. Congratulations, Pamela. For this, I will also throw it back at you, Lawyer Eunice. You guys are
Yes,
doing a wonderful job in the.
yes. And Pamela has been working with us for a number of years now. This is something that I think will propel her to even do more, because this achievement is not easy feat. Most people will just go to degree level, do their professional course, whether it's the LPC or the SQE, and then go into practice or whichever area they would like to obviously practice or work in. And she has been with us for a number of years. I could literally say probably for the past 5 years. And so she has really done well to combine work with her professional studies and her GDL as well. So this is a very, very big congratulations to her. And I want to see her go to even higher heights in her career as well with BW solicitors. So congratulations again, Pamela.
Well done to you, Pamela. And I believe that apart from what you're doing, you come sit in my seat. And when I grow old, you take over. I know, I know you'll be saying, oh, sir, please don't do that. Congratulations to you. We're so proud of you. And then we go on to the bit where we get you to know your rights. BWF Solicitors does that most of the time. And when things come up, we want you to know, what you need to do, and then stay on the right hand side of a law. We're talking about fee waiver. Why does it matter? The Home Office application fees are costly, around £3,908.50 per person in the UK, and over 5,300 from outside of the UK. This must often be paid every 30 months. But if you are applying based on human rights and can't afford it, you might qualify for fee waiver. So let's look into that a bit more detail. What is a fee? The fee waiver means that you may not need to pay the application fee, you may not need to pay the immigration health surcharge. It's available if you are applying based on your human rights and you can't afford the fees. Moving on, we ask ourselves who can apply. You can apply for a fee waiver if you're applying as a parent or partner under the 10-year route, as a parent under the 5-year route, as a parent under the 5-year route if your partner is exempt from the income threshold, and also based on Article 8, private life and family life, or any ECHR right. Then also you can apply on a discretionary basis. For instance, if you have refused asylum and victims of trafficking, these are the categories of people who can apply. Will it affect my status? No. Applying for a fee waiver, as it were, will not affect your leave to remain application or its conditions. So don't you worry about that at all. Then you ask the question, where should I apply? In time, obviously. We often time tell you that procrastination is a thief of time. So if you have to do it as quickly as you can. And it says that if you are in the UK, apply before your current leave expires, apply as soon as possible, as I have reiterated. And once you apply, your existing rights continue under Section 3C, leave under the Immigration Act of 1971. Right. So, how to do it? How to apply online only? Listen, it's free of charge. So if you apply, include dependents on the same form. After submission, you have 10 working days to upload your supporting documents. What do I need to prove? Um, you only need to show you can't afford the fee. You do not need to prove you can't borrow the money. So submit your bank statements, you, your sponsor, and your dependents. Submit money statements. These are accepted, so you submit that as well. You list all your income, expenses, the financial support, and this one is optional but very useful. You do a cover letter, and in the letter, explain your financial situation and anything that is unclear on the form. Then, when you have applied, if it is granted, you will receive a unique reference number. You must apply for leave to remain within 10 working days from the date of the fee waiver decision. Then remember, the date of decision and receipt are usually the same time as decisions are sent by email. This is quoted from paragraph 34C of the immigration rules. Then, next, if you are refused, so there are two scenarios: you could be granted or refused. If you are refused, if you had valid leave when applying, apply and pay the full fee within 10 working days, or you risk becoming an overstayer. If you didn't have valid leave or still do at the time or the date of refusal, you can either pay the fee or submit a new, better prepared fee waiver application. So if you're refused, sometimes it's not just the end. There may be questions you did not properly answer, so you can reapply. Then finally, fee waivers can protect your rights. So don't delay and ensure your evidence is strong. If you need help preparing application or supporting documents, you know where we're going? BWF Solicitors. Contact us on 0208 493 7340. In Ghana, you can contact the Ghana number and office on 055 589 5959. In emergency situations, 077 127 61884. Or send an email to BWF Solicitors, or you can visit BWF Solicitors on all social media platforms. So, those are your rights. Know them. Lioness, anything you want to add before we move on?
Not really, but it's good to know that when it comes to fee waiver applications, it can be done both in country and out of country as well. So if you are making those fee waiver applications, make them in good time, as it takes about 3 to 6 months for a decision to be brought by the Home Office.
Okay, so as I said, and I want to reiterate, if you need any support, call BWF Solicitors 0208 493 7340. Don't forget, if you have any feedback, put them on there for us. There's an update this week. In fact, it's been all over. Everybody is talking about the immigration white paper that has been published. Listen, I know lawyer units were created, but these are proposals that have been put in. They have not kicked in yet, but know what the main changes are. I said the immigration white paper has been published. It contains proposals for future legislation. Let me take you quickly through what the changes are. One is the standard period for settlement in point-based system routes. This is doubled to 10 years. Initially, it was 5, but now, if it does happen, it will be 10 years. Graduate visas will be reduced to 18 months. Understand initially it was for 2 years, now it will be 1.5 years. The immigration skills charge is to increase by 32%. A new temporary shortage occupation list will be used for roles below RGF6. When I finish, I'll get Lioness to uh, give us a bit more detail on that. Social care visa from abroad route is to be closed. Is to be closed. Take note of that. Skilled worker dependents will have to take the English language at level A1. I want to say again that white papers are policy documents produced by the government that set out their proposals for future legislations. So these are not laws, but they are proposals for a future date. More details will come when we do have them. Lioness.
Yes. So, as you rightly said, white papers are usually policy documents that shows the government's proposal for a new law or a new legislation. And this particular white paper is detailed. So it's very informative. It has 82 pages. And so it's basically the government putting down what their future plans are in regards to the immigration laws that were brought into force after Brexit. And they are very, very dire. I think most people were not expecting this on Monday, on the 12th of May, when the government decided to issue this white paper. And the Prime Minister announced it on the news. And so everybody was made aware that these were the proposals that were coming into play in terms of Parliament having to go through what these proposals are, and then we would see when they become law. Very, very quickly, when it comes to, I know the health and care route, a lot of people have been talking about the fact that the government are seeming to now put this shut this route completely when it comes to entry clearance applications. And so most employers will have to make sure that if they are looking to employ anybody from outside the UK, they do so quickly before the law comes into play. And so this route will be closed, but they will offer a transitional period for those healthcare workers who are already in the UK up until 2028. Another thing to also look at is the fact that they are going to increase the approved skill level. So most people on the skilled work route would have had to complete a qualification of a sort which would have met the required skill level of level three. Usually, that is comparable to an A level. Now they're saying that anybody who would want to come on the skilled work route would have to meet a required qualification framework level of a level six, which is the level of somebody who's completed an undergraduate degree. So most people who would wish to come and work in the UK now would have to show that they have a qualification for the job role, which meets that required framework level six that they are looking for. And also they're looking to increase the salary level again from the 38,700 per annum, which they introduced last year. And we are not sure what the increase is likely to be. As you've also rightly said, when it comes to those on the graduate route, we know that for those who have completed an undergraduate degree or a master's degree in the UK, you can apply onto the graduate route for an extra 2 years. The government is now saying that they are looking to reduce this to 18 months, which is a year and a half. They haven't said anything about those on the PhD route because most people who complete a PhD degree in the UK would have an extra 3 years postgraduate leave to remain. So this is to do with those on the graduate route who have completed an undergraduate degree or a master's degree. And I mean, we hope to see this not come into force, but they're proposing that it will be reduced to 18 months. And I think the question on everybody's mouth is the fact that now the settlement period has been increased from 5 years to 10 years. And so those on the skilled work route would usually have to complete 5 years of limited leave to remain before they can apply for indefinite leave to remain. But currently, the government is saying they are going to look to introduce it to a 10-year period. I remember when Tony Blair was in power and his government increased it from 4 years to 5 years. And now they're increasing it from 5 years to 10 years, which is double the period that we were expecting them not to obviously bring in, but they're saying that they're going to double the period by which a person who has come on the skilled work route will be able to apply for indefinite leave to remain. So this is in general, not just for those on the health and care route, but those on the skilled work route will be looking to have completed 10 years before they can apply for indefinite leave to remain in the UK. And I know for those who are employers, they will not be looking very pleased with the fact that the immigration skills charge would have to increase by another 32%. So not only have the salary levels increased, or are they going to increase further in the future, but they will have to be paying an immigration skills charge for every year that they choose to take on an international migrant worker. So obviously that is also another expense to the employer when it comes to an employer trying to offer a job to somebody who is an international migrant. And so, yes, there are a lot of things under this government white paper, but just briefly, we've mentioned the key points which we believe that a lot of viewers may know somebody who is under this category. So most of the proposals are to do with those under the skilled work route or the student route. And so if you know anybody who is under any of these routes, then I think that it would be good to pass on this link so that they may also have a listen and then see for further updates later on in the future once it becomes law.
I see in the comment section, Ade Taribu has put that the immigration proposal is scary. Well, obviously, yes, things are changing, and I would advise that if you have anything to do, do it now and do it quickly. Don't waste time. If you need any support, just contact BWF Solicitors. The numbers, as we keep saying, 0208 493 7340, and they will be able to help you. If you're outside of the UK, 055, especially in Ghana, 055 589 5959. Well, it's not the end of the world. So let's see what other piece of information we can arm ourselves with before we move on to our main discussion. Long term sickness and a dismissal. We don't like it to happen, but sometimes we get into certain conditions that means that we would have to stay away for a long time from work. And what are the laws saying about that? Can somebody dismiss you when you are away on a long term sickness? When an employee remains on long term sickness leave or has a recurring pattern of time off work due to illness, there may be grounds for lawful dismissal for sickness absence, provided certain criteria are met. And what are these? Long term sickness absence with no recovery, long term sickness absence where no return to work plan can be agreed upon, then pattern of sickness absence. Dismissal due to incapacity and the individual's inability to perform tasks is one of the five potentially fair reasons for dismissal. However, the employer must follow and allow a fair and lawful procedure before dismissing someone due to sickness absence. Panel versus Royal Mail case of 2024 has brought this to the fore, and we want to look at that. Linus, it might not be my fault that I am not well. It's occurred for a long time. I've been on and off several times. Why should they sack me? They should allow me to work because it's not my fault. That's what ordinarily will ask.
Of course, and I think most people who may be incapacitated due to one reason or the other will be looking to see if they can go back to work in the first place. Maybe your incapacity may render you immobile, so it's not going to be a good idea to go back to work with a wheelchair because maybe there hasn't been some adjustments made to your working role. And so you have this case of Panel versus the Royal Mail, where the claimant, Mr. Panel, is saying, well, I have this disability and I think that I was dismissed unfairly as a result of discrimination due to my um, obviously my disability. And the court, which is the employment tribunal, had a look at the claims that he brought into court, and they decided that there wasn't any unfavorable treatment towards him per se. And they said that any sort of treatment that he may have gone through was proportionate means to a legitimate aim. And so, if he's saying that the dismissal was due to discrimination of his disability, the employer would have to prove that there was a fair reason for his dismissal. And the Employment Act of 1996 gives some fair reasons by which an employer can dismiss an employee. And that also includes an employee's capability and their qualifications for the role. So the capability may include things like this employee's skill level, their mental and physical well-being, and then their aptitude to work. So if for one reason or the other the employee is physically unable to carry out their role. Maybe as a postman, he would have to deliver letters to people's doors. Um, I'm just thinking to myself, what reasonable adjustments can be made if, for instance, the person is incapacitated? Maybe they might move them to a different role, maybe where they would need sorting out of the documents, but that will also have to be an agreement between the employee and the employer. And so, if he is still insisting to remain in the role that he is in, the employer must show that there were fair reasons to his dismissal and that they made reasonable adjustments to his work space and his role as well. And obviously, the employment tribunal found that there were no unfavorable treatments because they could not have made any adjustments whatsoever to his role regarding their resources and the things that they could have put in place. Was just not feasible. And so it means that in cases where your disability or your physical um, incapacity would lead you to not able will lead to you not being able to carry out your role, then you might as well say, yes, employer, I cannot seem to fulfill the role that you've given to me. Maybe I might want to rather go on redundancy rather than to remain in my role. And unfortunately, Mr. Panel was not successful in his claim. But I believe that depending on the person's incapacity, depending on the employer's means by which they can make adjustments, um, in different circumstances, different rules may apply.
So obviously, if it does happen that they may have to inevitably lay you off, they would have made reasonable adjustments to accommodate you at work, and you would have been treated fairly if you were asked to leave, isn't it?
Yes, definitely. They would have to take you through the process of asking you what reasonable adjustments you would like them to make. And if they can make those adjustments, they would give you further feedback. And if they can't make those adjustments, they will let you know that they would have to let you go because those adjustments cannot be made.
All right. So yeah, employee long-term sickness and dismissal. There's a case, Panel versus Royal Mail, a case of 2024. So then, in that case, I would have this question to ask you, not to lawyer, but to my friends, my brothers out there watching us. Nimoy has suffered from depression and anxiety since 2012. In April 2018, he received a disciplinary warning to stay on his record for 2 years. Just before receiving the warning, he went on sick leave again. His employer had made multiple attempts to meet and discuss a return to work. However, Nee had indicated that he would not return until the disciplinary warning was withdrawn. He was dismissed and he sued. Which of the following are likely outcomes of the suit? His claim will fail, and the employer has taken steps to make reasonable adjustments for him. Um, he will succeed because he was unwell and the dismissal is deemed as too harsh, or he will fail because he's been sick for a long time. So think of what we have read, think of what lawyer Eunice has said, and look at Nimoy's situation. We will come back to it and see which answer you gave and which would be the correct one. But before then, I want to say thank you very much for staying here. Thank you very much for allowing us to come into your homes and taking part of your Saturday afternoon. We're delighted, but we need to say thank you to BWF Solicitors as well. And then again, I would want to reiterate that each year you help yours truly to solicit for funds so we buy incubators for needy hospitals back in Ghana. We're doing this to save lives. So on the 25th of May, that is a week after tomorrow, the 25th of May, which is the Sunday before the last bank holiday in May, we are gathering in Reading, where we will be organizing a musical show. Alexei Champon, Mamisewa, and um, the that lady. I want to remember that her name. I will come. It will come in the advert. But then we're saying that please come support us, raise funds for the incubators. Emmanuel Praise 2025 is up at the corner. Do come help us as I plead with you. We'll take a break, and when we come back, we'll go into our discussion. And remember, what we are discussing this afternoon is how to apply for British citizenship as a child who has come to join as parent in the UK. How do we do that? We'll get into it right after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
AA Music Entertainment presents Emmanuel Praise on the 25th of May at the Pavilion, 143 to 146 Oxford Road, Reading, RG1 7UY, featuring Irabna, Joyce Blessing, and hosted by Alex Achampo. Show starts at 6 p.m. with a concession price of £15 for children from 5 to 16 years old. Tickets are £35 standard, £60 double, £60 VIP. Includes a VIP seat, meet and greet the artiste, take pictures with the artiste, VIP snacks, water and drink. Get your tickets at alexichampon.com or call 0744 741 7321. Emmanuel Praise with Irabna and Joyce Blessing and hosted by Alex Achampon. It's guaranteed to be awesome.
And welcome back. Thank you very much for sticking around. When can I apply for British citizenship if I'm joining my parents here in the UK from outside? BWF solicitors want to say thank you very much for helping us to unravel this, and we're going to go through this with our guest and resource person, lawyer Eunice Champong, a partner of BWF solicitors. Lioness,
Hello.
that route to indefinite. I know a lot of people have traveled that way, but has not been very smooth for them.
Mm.
Conditions to meet and all the rest of it. How do we do that, and especially with children? So maybe I'll get you to get into those definitional situations where we look at a child, we look
Mm.
at British citizenship, we look at joining parents from outside and all the other details about it. So now the ball is in your court. Please take us through.
Thank you so much. And thank you for the question as well. I think this is something that may cut across board to anybody who has brought a child in from Ghana or whichever country they've brought the child in from. And so, in most cases, if they brought the child and the child was granted limited leave to remain, they will be looking for the child to be granted indefinite leave to remain, as you said, before they can register them to be British. There will be circumstances where parents or guardians may bring the child in and they will be granted indefinite leave to enter. And in those scenarios, these are scenarios mostly under paragraph 297 onwards of the immigration rules, where a parent may have to show sole responsibility or that the other parent is deceased, or that there are compelling and special circumstances in which the parent or the guardian or the relative will have to bring the child into the UK. And in those circumstances, they will grant the child indefinite leave to enter the UK. And so when it comes to children joining their parents or their relatives here in the UK, most times we know that if after a period of limited leave to remain has passed, they will be looking to also be granted indefinite leave to remain in line with their parents or guardian who they have come to join here in the UK. And so, specifically, when we say that you are registering a child to be British, we are expecting that the child would have also been granted indefinite leave, or what we usually call it is settlement. So once a child has been granted settlement, you are looking to see if you can register this child who has come to join you here in the UK. There are other reasons or basis for which a child can be registered to be British, and that would include a child who was already born here in the UK whilst their parent was settled already, or whilst their parent was a British citizen. And so, if that is the case, then the child who was born here in the UK would be automatically British because before they were born, their parent was settled or their parent was British. You also have a child who, for one reason or the other, may have been born here. Their parents may not have settlement or British citizenship, but then they have lived in the UK for the first 10 years of their lives and they are going on to register as British citizens, which will mean they will have to complete an application for registration. And you will also have scenarios like what our question has led us on to, where children are coming from outside of the UK and are looking to register to be British. And so, in scenarios like that, the expectation is that the child already has settlement or the child already has indefinite leave to remain in the United Kingdom. And if the child is a child of a parent who is already settled and is British, so not just settled and is also British, then the Secretary of State may deem it fit to register this child to be British in line with Section 3 one of the British Nationality Act of 1981. So,
Well, let me come
yes,
in briefly and ask. You use an operative word here, may deem it fit to register the child. So does it mean that if I have a child outside of the UK, I am settled or I'm a British citizen, and I want to bring such a child in there, it is not automatic for that child to be registered as a British person?
no, not at all. So it is not automatic for a child who has come outside of the UK, has come from outside the UK, and even has settlement to make the application for registration and then automatically they are granted. It's unfortunately not the case. There is that operative word, like you said, may deem it fit. And so when we say may, it is at the discretion of the Secretary of State. And so there are policy guidelines that they follow in terms of looking at certain criteria when considering such applications. And they would check to see if the applicant who is a minor, when we say minor, we mean a child who is under the age of 18. So they will look to see if the applicant who is under the age of 18 does meet those criteria in place before they go ahead to grant them citizenship.
All right. So then, what criteria do we have to meet? I
Yes.
am already the child of this settled person. What else do I need to show?
Yes. So, when it comes to children who are making applications for registration, especially those who have come from outside the United Kingdom, the Act is very clear that the parents, either one or both parents, must be British, and they would have to also show that they haven't left the UK for a period of time, which is usually 3 years before the child was born, outside of the UK, or in circumstances where the child has now come to join the parent here in the UK, they would have to show that the child haven't joined their parents. Usually, if it's a child under the age of 13, there's a residence requirement which says that they must show that they have resided in the UK for at least 2 years before the registration of that child. If they are 13 and above, they would require that they have lived here for 2 years or more to be able to show that they meet the residence requirements that they have put in place. When it comes to the fact that this child who has now joined their parent here in the UK is also saying that they want to be British, they look at the child's good character requirements. And so, usually, in this country, any child who is above the age of 10 would have to show that they are also of good character. And you would need to put in your school details. So, they will make checks with the schools. And if you have been in trouble before with the police, they will know because they would have to check with
Others.
police data to see if there has been any criminal offense that has been committed by yourself, or there has been any form of convictions whatsoever. And so they have to make those good character checks as well. Another requirement is the fact that they will have to check that the parents of this child consent to this child becoming British. And so, yes, if either parents, even if one parent is British, they would have to make sure that they have the consent of the other parent who might not be British, to consent to the fact that they would want their child to be registered as British as well. And not forgetting, when it comes to children making these applications, they want to make sure that as much as possible, that any child who is making this application for registration would have to also show that as much as they have come into the UK and have lived here for a period of 2 years or more, if they are above the age of 13, that they also have shown that if the parent who is settled here in the UK is also making an application, they are making the application to naturalize whilst they are making the application to register as British as well. So these are a few criteria that they look to, and they want to make sure that um, both parent and child have every intention to make the UK their home,
Right.
their permanent home.
Let me then ask. You mentioned that both parents will have to give their consent. I'm looking at a scenario where one of the parents is here living in the UK, the other is living outside of the UK, for instance, Ghana. Do we have to have both of them give consent that this child would be registered here in the UK, or it has to be the person that has sole responsibility of a child that will have to give consent, and we can ignore the other one?
Okay, so I like this question because you have put in the picture that there is sole responsibility.
Responsibility.
So
Yeah.
we'll consider the scenario where there is sole responsibility and the scenario where there is no sole responsibility or the insurance responsibility.
Okay.
So if you are saying that a parent has sole responsibility for the child, in most cases, the child has been brought to the UK because the parent has been able to show that they have sole responsibility for that child. And that was the basis for which they were granted leave to remain, or they were granted indefinite leave to enter the UK. And so, in most cases, to be able to show sole responsibility, it means that the other parent must have abdicated their role or abandoned the child, or that the other parent is deceased. So if the other parent has abandoned or abdicated their role, then it means that the parent with sole responsibility may not even know their whereabouts because they haven't been in contact with them for that period of time since they brought the child into the UK, or for a while before they brought the child into the UK. So, in such circumstances, you would have to say that the whereabouts of the other parent are unknown, and therefore you are giving your consent as the parent with sole responsibility for this child. Obviously, when making this application, you will be including the child's original birth certificate, and they will make their checks on their records to find out if that is so. There are cases where obviously there would be a parent who is looking after the child, and the other parent might also be in the UK, and they may both have British citizenship, um, but it might be the case that the other parent is not on good talking terms with the parent with sole responsibility for this child. In that case, most times they might ask you to get a court order to prove that you have child arrangement order in place to have this child with you on a permanent basis as well. And most times, once you have a court order, they are okay with you going ahead with the application based on you giving your own consent. When it comes to parents where there are joint um, parents playing their role in the child's life, of course, you can go ahead and sign where both parents may be, should I say, settled and British and maybe separate where their parents may have separated for one reason or the other. You can still get the consent of the other parent even though you are separated from living together. So, in all those different scenarios, you would definitely need the consent of both parents unless you are saying you have no trace of the other parents whatsoever.
If you just joined us, you're live with us on BWTV, and we are having the community and the law. When can I apply for British citizenship as a child who's come to join his parents in the UK? Our resource person and guest is lawyer Eunice Champon, partner of BWF Solicitors. You can keep your questions coming through. Send them via text 07 39920848, or you can put them in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. Or when the lines are active, you can call on 0208 493 7345. 0208 493 7345. Your question could be about the topic we're discussing, or it could be any other issue that's bothering your mind. Or if you have any comments to also pass, you are allowed to do so. Learners, let's get back to our discussion. You mentioned that there are criteria. I've met the criteria. I know that I can apply. I have given my consent. The other partner has given their consent, and all the rest of it. How do I go about it?
So, when it comes to making the applications, most applications now for living or remaining in the UK are online, and so are naturalization applications. So, if you want to go ahead and make this application, in the case of children, like you said at the beginning of the program, there are fee waiver applications that can be made for children under the age of 18. So, if indeed your parents is unable to pay for the application fee, which is currently £1,012, then they can go ahead and put in a fee waiver application to let the Home Office know that they are unable to gather the funds to put in your application. So there is a fee waiver application that they can complete. As you rightly said, they can make that fee waiver request. And once a decision is made, if they're successful, they can go ahead and make the application without paying a fee to the Home Office. If they are unsuccessful, because obviously there were some documents that were not um, provided to the Home Office at the time, they can go ahead and make another application for fee waiver. If they do have the funds, they can go ahead also to make the application directly on the government website. You'll be looking at a form MN1. So it's a form MN1 which you would use to make the application. You will be completing the application online, and also you would need to put in all the details that they require. Most of the questions are very easy going, and so I don't think most people will have any trouble answering the questions. Also, you would need referees. Referees are people that can attest to a person's identity and their character as well. and they would usually need two referees. So they say that at least one referee should be a professional person. So the other one may not be a professional person, but at least one of them should be a professional person and should be between above the age of 25, should I say. And so, as long as they're professional, they're above the age of 25, and obviously they can attest to your identity and your character, then they can go ahead and obviously referee for your application. And it's not both who have to be British. They say that at least one of the referee has to hold a British passport. So that is a good thing, because if you are not getting both referees who have British citizenship and you have only one who is able to provide their passport number, then it means that at least the other referee may be of another nationality. Yes, so once you've been able to get the details of both referees, that will be completed on the online application as well. And then once you have paid for the application online, you will print out the referee pages, which will be sent to each referee with a copy of your photograph. So you would need to take a passport sized photograph, which will be put on the page that the referees will be signing on. And then you will also need to print out the page for the parents' consent. So both parents will have to consent either within the UK or outside of the UK, unless you are saying that you have complete responsibility for this child, then you would explain why the other parents cannot give their consent. So, no matter where the other parent is, they will need the consent of both parents for the child to be registered as British. And then the child will have to attend a biometric appointment. So we all know that when it comes to making a valid application, you would have to complete the online application, pay the required fee, enroll your biometrics, which is usually done at a biometric appointment, and then prove your identity. So you have to take a copy of your passport with you. If it's a child who has never been registered before, that will be a different scenario. But in a case where we are talking about children who have come to join their parents here in the UK, they need evidence of their passport. And so they will need to take their original passport with them, which is proof of their identity and nationality, to their appointment. And so once the biometric appointment has been done, documents submitted to the Home Office, then you would be waiting to see within the next 3 to 6 months when a decision is made. In terms of documentation, you need to provide your passport, like I said. You need to provide evidence of your parents' British citizenship. If you are making the application together with your parents, so maybe your parent has indefinite leave to remain and they are now applying for naturalization, you will need to provide evidence of their application number, for instance, and a copy of their settlement. So if it's a biometric card which shows their settlement, or they have the Home Office letter that shows their settlement, you will provide a copy of that. You will provide a copy of your settlement here in the UK. You provide proof of address for the past 2 years, depending on your age. If you're under the age of 13, any current proof of address will do. If you are above the age of 13, you would need at least 2 years proof of address, and then you can send off the application. If they need any further documents, they will let you know. Most times for children, any school letter or GP letter will do with the application. And so once you have sent that, you just have to give the Home Office at least 3 to 6 months to process your application, and then you would have your certificate sent to you by post, whereas adults would usually have to go for a ceremony to have their certificates handed to them.
Okay. Now, you have mentioned that the Home Office may, and you explained that. So it means that it's not a given, it's not a tick box thing.
Mm.
So the application is either successful or is refused.
Mm.
In the case of where it's refused, because it's a discretionary thing, are you going to be giving the right of appeal?
So with nationality applications, unfortunately, there is no right of appeal. It is only when you've been deprived of your citizenship that's when you are given a right of appeal because they are depriving you of something which you hold so dearly. Unfortunately, you cannot have a right of appeal. The only thing you can do is to reapply if, for instance, they refused it on the basis that, well, you don't meet the criteria. So we expected you to have lived here for a period of 2 years at least, and you have not yet lived here for a period of 2 years. So once you are able to meet the criteria, you can reapply, and then they will consider the application. Most times, the refusals that can be obviously done with. So when it comes to somebody who has committed an offense, then obviously we have to advise further whether they can reapply in terms of making another registration. But in most cases, yeah, you can go on to reapply once the basis for refusal is no longer an issue.
So if I applied for a fee waiver, and let me even put it this way, can I apply for a fee waiver for this kind of registration, naturalization?
Yes,
Yes.
as long as the child is under the age of 18, they can apply for fee waiver when it comes to nationality. Unfortunately, adults cannot apply for fee waiver with nationality applications, only children who are under the age of 18.
Right. So my parents applied for me through a fee waiver, or they applied for a fee waiver. Fee waiver was granted, but the main application was refused. When I'm applying again, can I go through the fee waiver route, or I'll have to apply for another fee waiver because previously I couldn't afford it?
So, like you previously said, once you make a fee waiver, you are given a period of 10 days, only 10 working days to make the application. Otherwise, the fee waiver code they gave you basically, should I say, runs out. So if you don't make the application within the 10 days, you have to reapply for another fee waiver um, decision to be made before you can make the actual application for registration. So if you were refused, you would definitely need to make another application for fee waiver. Once that decision is made, whether you were granted or not, you will have to make the application within that 10-day period to be able to have that grace granted to you. So, yes, you can apply for another fee waiver after a refusal.
Okay. I'm going to ask a bit of a statistical question, but let me put it this way. The application for naturalization and subsequently becoming a British citizen, how often is it refused?
Well, to tell you the truth, I don't know the numbers on top of my head, but in my experience, they hardly refuse children's applications unless you don't meet the criteria. So, like I said, if your parent, for instance, is not applying for naturalization with you and they only have settlement, for instance, they will refuse the application. If you are saying that you are a child who has been brought into the UK and you are 13 and above and you haven't lived here for 2 years, the application is likely to be refused. If you are saying that you are intending to make the UK your home and you have committed certain offenses, unfortunately, that will not look good on you. And so it's in your best interest, I would say, to make sure that the criteria has been met when you're putting in the application. Most times, once you are able to meet the criteria, you are likely to be granted citizenship as a child or as a minor. If you don't meet the criteria, most people think because it's discretionary, they can just try their luck. It's not about trying your luck, because you will try your luck, and if you are paying for it, that money is gone. You cannot ask for a refund of that money to be paid back to you just because it was refused. So as much as possible, you will have to meet the criteria. And I know that people say that, oh, but before um, the child turns 18, can I not do anything? Maybe the child has lived there less than 2 years and I want to make the application before they turn 18. Unfortunately, no. Just because they're turning 18 is not an excuse to you not meeting the criteria that they have put in place. So if the child hasn't lived there for 2 years and they're turning 18, unfortunately, they will now have to apply as an adult rather than as a child, and they would have to go through Section 6, where they would have to have lived there for a period of 5 years, and they would have to show that they are a person of good character. They will have to meet the English language requirement, the life in the UK requirement. They must not have been absent for the 450 days within that 5 year period, and so on and so forth. So unfortunately, if the child is turning 18 and they don't meet the residence requirement, they will have to apply later on as an adult.
You get this only on the community and the law, and we're doing that courtesy BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors, they help you with your immigration matters, legal issues concerning your employment, property acquisition, wills and probate, and any advice you would want to have when it comes to the law. Contact BWF Solicitors and they will help you. They are on the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters, North London. The postcode is N15 4NP. And as Sandra has put in the comment section down below, either on Facebook and YouTube, you can get various buses that will take you on the Tottenham High Road, or go via the underground, take the Victoria line, get off at the Seven Sisters station, use exit number 2, and that will take you to the front of the Anna House. Climb up to the fourth floor, Monday to Friday from 9:30 to 6 p.m. You will get them there. Call them on 0208 493 7340, 0208 493 7340, or in emergency situations 077 127 61884, 077 127 61884. If you want to get in touch with Lawyer Eunice directly, 0753 581 3910, 075 3581 3910. And she's happy to support you. Last week, if you were here, you would have gotten the assurance that, yes, you can call her and she'll help you book an appointment, sit down with you, either face to face or via the internet or electronically. And your situation will be so easy for you to handle. With BWF solicitors, we often say are trusted partners when it comes to the law. And this afternoon, we've been discussing very extensively how and when to apply for British citizenship when you have joined your parents from outside the UK. We're taking a break. When we come back, we'll pick up your questions, your concerns, put them in the comment section down below, either on Facebook at BWF Solicitors, at BWTV, or you can send a text 07399208468, or you can call. The lines are active, 0208 493 7345 after these messages.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
AA Music Entertainment presents Emmanuel Praise on the 25th of May at the Pavilion, 143 to 146 Oxford Road, Reading, RG1 7UY, featuring Irabna, Joyce Blessing, and hosted by Alex Achampo. Show starts at 6 p.m. with a concession price of £15 for children from 5 to 16 years old. Tickets are £35 standard, £60 double, £60 VIP. Includes a VIP seat, meet and greet the artiste, take pictures with the artiste, VIP snacks, water and drink. Get your tickets at alexachampon.com or call 0744 741 7321. Emmanuel Praise with Irabna and Joyce Blessing, and hosted by Alex Achampon. It's guaranteed to be awesome.
Welcome back, and thank you for sticking around. We're still live on BWTV, and we're having the community and the law. When can I apply for British citizenship as a child who has joined as parent here in the UK? A resource person and guest from the fold of BWF Solicitors, lawyer Eunice Achampo, so to speak, is here with us. Lawyer Eunice, yes, with your permission, let's pick up some of the questions that people have brought in. I've said that you can put them in comment section down below, or you can send them to our text message line 07399208468 or call 0208-493-7345. Now, Netia comes up with the first one. Are you able to give mortgage advice in the UK, lawyer?
No, unfortunately, we are not conveyancers, or we do not specialize in property law. So you need a conveyancer to give you advice on getting a mortgage property. The mortgage itself is the funds that you use to pay for the property. So if you also need advice on the mortgage, which is the funds itself, then you need to speak to an advisor within the bank.
Oh, okay. So obviously, you are signposting people to where they should go. Speak to your advisors in the bank, and they will help you. But not BW, they don't do that. Ato Kwame, despite Hagan, says that the CEFR level B1, that is ISE1, Can that be used to make indefinite to leave to remain when the time is due? Um, you've introduced a lot of abbreviations, and I hope,
So
no, you are here, so lawyer will help us. Don't worry.
yeah, the CEFR is a Common European Framework required level. He says level B1. So yes, as it stands, you can use a level B1 to make an application for indefinite leave to remain and naturalization as well. I know that with the new laws that the government is proposing, they are introducing English language tests for dependent spouse of those on the skilled work route. So that is completely different for those who are already in the UK, who are already on a limited leave to remain on other routes. You can still complete level B1 speaking and listening test, and you will be granted a pass for your indefinite leave to remain application. Yes.
Yes, keep them coming through. If you've got a text, yes, you know the text number 0739920848, or put them in the comment section as Lydia has done. I'm asking this question for my friend. Can he apply for indefinite leave if he has his leave to remain in November 2014? Can that person apply for indefinite leave to remain now?
So I'm hoping. Well, I don't know the category on which under which he made his application, but in most cases, if you've resided in the UK lawfully for a period of 10 years, you can make an application once your 10 years is up. So if he can show that he has lived in the UK and he has lived here continuously for a lawful period of 10 years, then yes, he can make the application anytime soon.
So, in this situation, he's talking about November 2014, which means that he's gone into 10 years and a few months.
Okay.
Um,
Yes.
if, for instance, he has been outside of the UK, maybe on holiday or for any other reason for a period of time, would that be deducted from the length of time he has lived here? Does he have to live here continuously
So
without?
the word continuously is a requirement which sort of makes reference to the fact that they expect that you might go on holiday, but they also deem you to call the UK your home. And so if this is your home, then they do not expect you to be living elsewhere. And so in counting those lawful 10-year period, they would consider any absences outside of the UK. And usually they will expect that you would not be absent for at least 6 months within a 12-month period. So, if, for instance, you are making your application for indefinite leave to remain and you have been outside of the UK for a period of more than 6 months within a 12-month period, unless you are able to give very reasonable reasons why that is, then your application for indefinite leave to remain under the 10 years law for residence will be refused. So most people are able to prove that they've lived here continuously for that time without being absent for that long period of time.
All right. So yeah, my friend, thank you very much for bringing that. That's your answer. We go on to the next one. Remember, the text line is also active. Can one benefit from new entrant fees if the person is on PSW stroke graduate visa? What's PSW? Why are you people giving me abbreviations and terminology?
Points based skilled work, I think. Yeah.
Uh,
So if you're coming in as a skilled worker or graduate visa is usually for those who have completed a student visa course here in the UK. So um, I believe that you are talking about the fees that were introduced in April of this year. So yes, if you are making any application under the skilled worker route or under the graduate route, the new fees that were brought in April of 2025 will be applicable to you. You will also have to pay the immigration health surcharge for each year that you will be granted. So if you're applying for a graduate visa for 2 years, you will have to pay the application fee plus immigration health surcharge, which is £1,035 for each year.
Victory upon victory. Thank you for that. Next, we have Nana Etiahene. Please, children, three children whose parents are British arrive in the UK with indefinite. Their ages on arrival 13, 11, and 9, respectively. At what ages or how many years should each one spend in here before they can apply for British citizenship? They were born abroad before both parents acquired their British citizenship. Lawyer.
Okay, so Nana Ituahene, thank you for that question. So these three children, it's good that they are both 13. I mean, they're all 13 and under. So depending on when they came, the child who is 13 um will have to show that they have lived here for at least 2 years or more before they can apply for naturalization. The other children, because both parents are British, they can apply for their registration as British citizenship. I mean, as British citizens at any point in time during their stay. So it means that if they would want to wait for the other child who is 13 to have met the 2 year residence requirement, then they can all make the application together. In that case, once they've also met the other criteria, the parents are British, they haven't got any criminal records, or they have to show that they are of good behavior. Both parents consent, and they are making sure that the UK is their intended permanent home. Then why not? They can go on and then make the application, which will be successfully granted to them.
0379208468, or you can call 0208 493 7345. When can I apply for British citizenship as a child who has come to join his parents in the UK? That's what we have discussed. But we're now taking your questions and comments. Put them in the comment section down below, either on Facebook at BWF Solicitors or BWTV YouTube, same handle. Good afternoon, lawyer. I'm due for indefinite leave to remain. I think it's ILR, not IRL. This should happen in February 2026. Can I do my English test now against next year?
Okay, so I'm sure he's making the application as somebody who is on the family route. So if, for instance, you're on the family route as a parent or a partner and you want to make the application, I mean, you said 2026. So hopefully by that time you should have done both the life in the UK and the English test. The English test has an expiry of 2 years. So you can go ahead and do the test now. Obviously, by next year, it will still be valid. So if you want to do the test, you can. And you will also have to take the life in the UK test as well.
Frank, thank you for that. And that's your answer. Keep them coming through. We still have some time to pick these one up. Hajman United. Oh, you lost yesterday, didn't you? You'll not be happy with me, but I was happy because we won. You should have seen my anxiety when I was watching football last night. Anyway, let's come to the law. When applying for naturalization as non-EU citizen holding permanent resident card for 10 years, do I need to include marriage certificate in the evidence requested? Although Home Office didn't ask for it, I'm married to an EU national. All evidences have been provided apart from the marriage certificate. Secondly, is my marriage or birth certificate compulsory in a naturalization application? Lawyer.
Okay, so in terms of the second part of the question, you don't necessarily need the birth certificate unless you're a child and you want to show that both parents are consenting, or you want to show your place of birth. When it comes to the marriage certificate, usually you would include that as evidence that you are indeed married, because on the application they will ask you whether you are married, single, unmarried partner, separated, divorced. So usually you would give them evidence of your marriage if you are married. And then for those who are married to British citizens, that is an important or a mandatory document, because you are showing that you are married to a British citizen, and therefore you do not have to wait 1 year after your indefinite leave to remain to make the application for naturalization. So your marriage certificate is important either way.
Hajj, Man United, thank you. We're moving on. Remember, I'll be bringing back the scenario for my quiz question based on the nugget we had earlier on. Let me just remind you of the nugget. When an employee remains on long-term sick leave or has a recurring pattern of time off work due to illness, there may be grounds of lawful dismissal for sickness absence, provided specific criteria are met. And these include long term sickness absence with no recovery, long term sickness absence where no return to work plan can be agreed upon, and pattern of sickness absence. Dismissal due to incapacity and the individual's inability to perform tasks is one of the five potentially fair reasons for dismissal. However, the employer must follow a fair and lawful procedure before dismissing someone due to sickness absence. And we picked on this one from the case between Panel and Royal Mail, and this was a 2024 case. So then I asked this question in this scenario that we have Nimoy, who suffered from depression and anxiety since 2012. In April 2018, he received a disciplinary warning to stay on his record for 2 years. Just before receiving the warning, he went on sick leave again. His employers made multiple attempts to meet and discuss a return to work. However, Nee had indicated that he would not return until the disciplinary warning was withdrawn. He was dismissed and consequently he sued. Um, there are three scenarios here. Which of them would be the likely outcome of his claim? His claim will fail, and the employer had taken steps to make reasonable adjustments for him. He will succeed because he was unwell and the dismissal was too harsh. He will fail because he's been sick for a very long time. Which of them? Think about it. Use the nugget scenario, the explanation that lawyer Eunice gave us earlier on, and then give me an answer. We will probably pick up one or two questions and comments before we take a quick break and come back to look at the scenario and the answers you gave. Daniel Opon, is the B2 English test equivalent to GCSE? Lawyer.
No, it is. I so I know that when you're doing the test at the test center, they give that similarity. But I don't think it is, because it's only speaking and listening, whereas a GCSE considers reading and writing and the rest of it. So when it comes to speaking and listening, B2, you're only doing it at a level which they call a common European framework level. So it's I don't think it's equivalent to a GCSE.
Okay. All right, Daniel, don't worry. You will be fine. You'll be fine. Speaking, listening, and having that conversation, you do that all the time, so it should be fine. Ofema for Priscilla, what are the requirements you would need before you get the self sponsorship?
Okay, so I know when it comes to self-sponsorship, a lot of people are looking to go onto that route because they want to start up a business and then try and get onto the points-based system. When it comes to the points-based system, you have the innovator founder route, you have the startup business route. Those are routes in which most people who are starting up a business would want to go into. And most times, apart from the fact that you have to have a good business plan, you need to also have an endorsing body that will endorse your business plan and your business altogether. And there are not many endorsing companies, and so it's good to do your research and get advice as much as possible when going ahead on the self sponsorship route.
Right. So, producer, I think we can take one more, maybe, and then we will take a break and come back to look at our scenario and the possible answers. We're still live on the community and the law. Kwame says, I've lived here for 25 years, but on the 10-year rule due for a second renewal this August. Is there any way I can apply for indefinite leave to remain without having to wait until the 10 years have expired or elapsed?
Uh, sorry, the reason why I'm laughing is because he says that he's done 2.5 years. He's going on his second renewal, but he wants to apply for indefinite leave to remain straight away. Um, that's a big ask because you're now going on your second one and you're already tired. Um, Unfortunately, if you're on the 10-year route to settlement, you will have to complete 10 years before you can apply for indefinite leave to remain. There is no jumping unless you can show that you meet all of the requirements needed to switch from the 10-year route to the 5-year route. And even with that, if you're switching to the 5-year route, you would have to complete 7.5 years to be able to apply for your indefinite leave to remain. So unfortunately, you cannot jump from the second leave to remain to indefinite leave. No.
Well, that's that. If you want expert advice, very cogent and very reliable one, you speak to BWF Solicitors, fourth floor of the Other House, 214 to 218 Tottenham High Road, Seven Sisters. Call them Monday to Friday. They work between 9:30 in the morning and 6 p.m. The number is 0208 493 7340. Or if you are in Ghana, you have the chance of contacting them in their Ghana office, and the number is 055 589 5959. And in emergency situations, 077 127 61884. And for lawyer Eunice, you can call. Somebody's just done something very interesting. Immediately, I mentioned the number you called. She's on TV. Please don't call now. She's on TV, so please don't call now. But the number is correct. So you can contact her directly if you want to. 075 3581 3910. 075 3581 3910. We take this break, say thank you again, and then come back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
So, welcome back and thank you for sticking around. Lawyer Eunice is still here, so I will be boxing you into my corner to find out what answers you give me for this scenario. I was talking about Nimoy, who suffered from depression and anxiety since 2012. In April 2018, he received a disciplinary warning to stay on his record for 2 years. Just before receiving the warning, he went on sick leave again. His employers made multiple attempts to meet and discuss his return to work. However, Nee had indicated that he would not return until the disciplinary warning was withdrawn. He was dismissed, and consequently, he sued. Which of the following are likely outcomes of his suit? His claim will fail, and the employer had taken steps to make reasonable adjustments for him. He will succeed because he wasn't well and the dismissal is deemed too harsh. Or he will fail because he's been sick for a long time. Now, give me your answers. Put them in the comment section below, or send me a text 07399208468. Samuel Edu has come up with the first one. It says number 2, he will succeed because he was unwell and the dismissal so to speak, too harsh. Mavis Akins is saying as number 1, his claim will fail and the employer has taken steps to make reasonable adjustments. Richard Opoku thinks it's number 1 as well. Let's see who else has another one for us. Emilia Kusi. Emilia thinks is number 2. He will succeed. Let's see who else has another one. Charles Afropong says is number 1. His claim will fail. The reason being the employer has taken steps to make reasonable adjustments for him. Andy Dankwa thinks it's number 2, agrees with other lady contributor. He will succeed because he was unwell. Mami Queen says number 2, agrees that he will succeed. He wasn't well and the dismissal is too harsh. Nana 4 thinks it's number 3, he will fail. He's been sick for too long. So why do you even do that? That's what Nana 4 thinks. Let's see what will happen. Next one says, Helena, it's number 1. His claim will fail and the employer has taken steps to make reasonable adjustments for him. I'll take the very last one. Isaac Asiedu thinks it's number 1. His claim will fail and the employer has taken steps to make reasonable adjustments for him. You can keep them coming through, yes, but I will go over to Lawyer Eunice to find out what the possible outcome or the likely outcome of Nimoy's suit will be.
I think that is very interesting to see the answers that people were coming up with, and it shows that people have been listening or they are taking note of what the actual nugget is saying. So we have Nimoy, who is obviously been on long-term sick leave, and just as he has come back from his sick leave, he attends a disciplinary hearing, and then he goes off sick again. And so obviously his employers are thinking, when is the recovery going to be in sight? So we have are options available in terms of what the employers are likely to do. All those who went for one, well done to you. Two and three, the reasons being, two says, I'm trying to see if I can see it
He
clearly.
will succeed because he was
The
unwell.
sun is
It's in your eyes, I know. He says, two says he will succeed because he was unwell and the dismissal is too harsh. And three says he will fail because he's been sick for too long.
obviously the dismissal cannot be too harsh because the employers have taken steps to ensure that he is on the road to recovery and will be coming back soon. So they have made steps to obviously contact him and find out how he's doing, how recovery is getting along, and all of that has come to no avail because he says he does not know when he will be able to recover. So the employer has taken reasonable steps to make sure that Mr. Nimoy will be able to come back into employment. And obviously, with the third one, um, it cannot be too harsh because the employer is there to make a profit and he is running a business. He cannot stop work because one employee is unable to come into work. He has to be able to fill in that role as soon as possible to be able to continue in his line or her line of business. And so, if the employer has taken reasonable steps to make sure that they are making adjustments to your working role, and unfortunately, you have not got a recovery in sight, they cannot be blamed for dismissing you because it is a fair reason to dismiss an employee if they are incapable of performing their role.
So it's number one, as lawyer has explained. Remember, the concept of proportionate means of achieving a legitimate aim is crucial in determining whether an employer's action is justified, although they are required to make reasonable adjustments for long-term sick leave to return to work. The employer's action were justified as they aimed to ensure regular and reliable attendance, which is a legitimate business objective. Law has said that they are in there to make money and profit. So if you are hindering that and they put everything in place for you to see reason with them, so to speak, you can't just say, well, I'm sick, so that's it. Employers, as it were, should continuously review their policies and practices to ensure they align with legal standards and are prepared to make necessary adjustments to accommodate employees with disabilities and difficulties. Well, as I said, if you need further discussion on this, if you need any advice on employment, if they can't give you directly, they will signpost you to where you're supposed to go. And what am I talking about? I'm talking about BWF solicitors. Call them on 0208 493 7340. And with this, we come to the traditional bit of our program where we have a review or a summary, brief summary of what we discussed this afternoon. And that takes us back to Lawyer Eunice.
Thank you so much, Oracle. So, yes, today our topic was to do with those children who have come to join their parents here in the UK and whether they can apply for naturalization after a period of time. So usually, once a child has been able to join their parent here in the UK, they must have completed a period of leave here to be able to apply for indefinite leave to remain. If they did enter the UK with indefinite leave to enter, that means that they've already been granted settlement and they can then go on to apply for registration as a British citizen under Section 3(1) of our British Nationality Act of 1981. Once a minor has put in an application to register as a British citizen, as the Secretary of State may deem fit, they may register that child or that minor to be British. And then there are the criteria under which the Home Office caseworker would be looking to see before that child is granted naturalization, or should I say British citizenship. Most cases, if the child is under the age of 13, if they've lived here for less than 2 years, they can go ahead to say that they've met the residence requirement. If they are 13 and above, they must have shown that they've lived here for at least 2 years before the application was made. Either parent, whether the father or the mother, must show that they have British citizenship. If neither of them has British citizenship, and one has settlement, they must be making the application for naturalization together with the child, at the same time, to be considered for registration. So, whether both parents are British or not, they expect that at least one of them who is not British is making the application for naturalization together with the child. And then also, they expect that the child will be of good character if they are 10 and above. They would usually take the details of the school and do their thorough checks as well. And then they would need referees to sign up, to say that they know this child and they can attest to the child's character. Also, there is a mandatory requirement for both parents to consent to this application. If for one reason or the other parent is unable to sign, you have to give a very detailed explanation as to why the other parent is unable to sign or give their consent to the application. And so, this is just a brief summary of what we discussed today. If you need any further details, do not hesitate to contact us from Monday to Friday from 9:30 a.m. to 6 p.m. On Saturdays, we do not have office appointments, but you can give us a call. We will have a brief discussion with you. And then if you need to come in or book a remote appointment, we will do that for you. Have a good weekend, and we will see you again sometime next week.
Need I say more? Have a good weekend. The sun is out. Enjoy it. If you need any legal help, remember, right at the corner, we have BWF Solicitors, fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, 0208 493 7340. In Ghana, 055 589 5959. In emergency situations, 00447712761884. Or you can visit us on our social media handles at BWF Solicitors. And remember, we live on TV at BWTV. On behalf of Lawyer Eunice, we want to say thank you to you out there who have really stayed with us for these 2 hours for us to go through this very interesting discussion. Eunice, thank you once again. Thank you to the family of BWF Solicitors, from the senior partner right down to the very last person being me. And to my technical producer, Professor Ade, for handling this so competently well. To Sheila Ankara and Padmo Dodu for their status. And to you other once again, thank you. We'll have another edition, same time next week. Until then, please be good.